I just want to say what a wonderful paper this was and how much I learned from it. I totally endorse every superlative that Mike has already put out, so I won't repeat that. This is terrific. It could be right in many respects. I guess I have one little, and I read the whole paper, not just the parts you told us to read, because it was so good. One little nitpick and then one question about the nature of the claim you're making. Both happen to be on page 52. The nit, which is we don't need to talk about, is whether in fact all the provisions of Article 4 that you're talking about actually are power conferring, because I am drawn to Salmon Chase's arguments that only the ones that confer powers expressly are power conferring and the rest are articles of compact, as he called them, between the states to be enforced by comity and not by Congress. So they may not actually be powers at all, and I would just point that out. That's the nit. The question I have is, I want to know, I'm curious to know the nature of the claim you're making about the four great aggregate powers, which appears in the next paragraph. When viewed from the perspective of text, history, and structure, the Constitution vested four great aggregate powers or comprehensive enumerated powers in the government of the United States. So I don't know what enumerated means here. And you say it a couple other places, but only a couple other places. The rest of it's implied. That's the title. So are you making a claim about the communicative content of what's there that says it actually communicates more than what we literally might think? And are you making a claim about implicature? And let me give you another example to see if this is what you're saying. So the Ninth Amendment, if you look at it purely literally as a rule of construction, the enumeration of the Constitution shall not be construed to deny or disparage. But it also, I think, has an implicature. The implicature is that there, number one, are rights retained by the people, other rights retained by the people, and two, that they shall not be denied, they should not be denied or disparaged. Now, it doesn't affirmatively say that. It only says it's only a rule of construction. But I think it implies both of those things, and that implication is borne out by Roger Sherman's draft that preceded the Ninth Amendment and that affirmatively asserted both of those propositions, that the people have these rights and that they should not be denied. So we have historical evidence that the implicature is not just in our imagination, it was there at the time. Is that what you're saying? That is, if you actually read these clauses generously enough and not so hyper-technically, you will see in them four powers. And it's still a government of limited and enumerated powers, but there's four clusters, and then the Constitution should be interpreted according to that. So what is the nature of your actual claim about these four aggregate powers is my question.
All right. Bob, I love the paper as well. Unlike Michael, I don't like Part 3C.
And that's because I think you're eliding the key issue, which is whether or not there's a federal body politic and what sort of implications follow from that. So Part 3C sets up the problem as if popular sovereignty solves our concerns because all powers, federal and state, are deriving from the people. But the key issue is what people? Is it a people of the United States? Is it people of the several states? And potentially, if we have a people of the United States, then the powers of the people, the terms of the social contract at the national level, are not just the powers of the government itself. They involve the purposes for which the union is established, and then the government, by implication, has powers to pursue those purposes for which the union is established. And so the argument then looks very much like what John was just laying out in the last session. And so it seems to me like you need to grapple with that problem. Is popular sovereignty an account of popular sovereignty deriving to the people of the several states, which is Jefferson's position, or is it the people of the United States as a single people? That, I think, is very much Marshall's position. And then the arguments that you're making, I think, look like arguments that actually support John's position.
Thanks also for a terrific paper. I just have, I guess, two small questions. One sort of follow-ups on Michael's comments to you. I guess my first question, maybe not so small, is this paper mistitled? In the sense of I'm not sure everything you're talking about is actually an implied power. They're all unspecified, right? They're not specifically listed somewhere, but I'm not sure they're all implied power. So powers that are incidental but lesser to other powers that are enumerated in Article 1, Section 8 may be implied under the theory of implied powers. But the foreign affairs power, if you buy the residual vesting thesis, I don't think we get foreign affairs by implication. It's not specified, right? But I don't think it's implied. It's there. Once we conclude that that's executive and that executive is vested, I don't think that's an implication. And maybe the immigration stuff, maybe there are inherent powers that are great, substantive, and independent, that don't have to, that ordinarily we would think shouldn't be left to implication, but I guess we're okay saying Congress has them anyway, like the immigration power. Maybe it's a subset of implied power, but I guess just put some thought to whether this is actually all implied powers or there's something else is the common thread. The smaller question I had is on this whole aggregate fiscal power. I'm not sure that the primary sources you cite actually describe a general fiscal power. They all describe the general fiscal operations of the government, or on I don't know what page I'm on here, but like page 54, when you quote, "It is the manifest design and scope of the Constitution to vest in Congress all the powers requisite to the effectual administration of the finances of the United States." Others, administration of national finance. Hamilton or Marshall and McCulloch says fiscal operations. Isn't that very different? I mean, you could have a constitution that says the National Congress shall have one fiscal power, the power to create duties. Every one of those statements would still be true, right? The government would still have fiscal operations. It would have to pay employees. It would have to, send out paychecks. And so I don't see in the primary sources where you get this aggregate fiscal power. They all seem to refer to just fiscal operations, which are true no matter what the scope of powers actually are.
Any response? Thank you all for those tidy questions.
Sure. Well, they're all great questions. So, Randy, yeah, I'm using it in exactly the sense I'm talking about. That is implicature, right? And maybe one easy way of thinking about this is if you ask most people who's in control of the foreign policy of the United States, right? The national government, the state governments, the two together. I think almost everybody would say, oh, that's the national power, right? And I don't think they'd quibble about, the foreign commerce power, the exchange of diplomats and all of that. The understanding, and this was also at the time of the framing, the understanding was the federal government would be in charge of foreign relations. Okay. And I think that's true about these other aggregate powers too. So yeah, I am arguing, and you expressed it really well. I wish I could have taped it. So when I make the next revision, I could plagiarize from your words. It's being recorded. Oh, it's being recorded. Great. So I'll use it. But I think it is an implicature argument. I think the problem with reading all of this as fiscal operations versus fiscal powers, first of all, I'm not sure what the difference is, but the bank went way beyond the enumerated powers granted to Congress. And the bank was doing some things that it wasn't even clear Congress could do, by itself. And one of the things that Hamilton talked about was his example of looking at national banks in other countries, that national banks generally are necessary for the fiscal operations of the government. But he was using in all these terms, as was Marshall, fiscal operations in a very, very broad way. And when you look at the stuff the bank was doing, it was exceptionally broad. Now, Hamilton did have his sort of standard alternative argument that, we can tie the bank to the enumerated powers. It's a convenient way to collect taxes, right? Because it's easier than requiring people to pay in coin, right? It'll be a source for borrowing. Of course, as Madison said, there's a huge circularity to this. at first we set up the bank, and we give the bank all the money in the United States. And then we say the bank is going to be a source for borrowing for the United States. Well, of course, as I got into later in the paper, what Hamilton was really talking about was using the fiscal powers of the United States to expand the economy of the United States. That was the purpose. That was Hamilton's purpose. One of his two purposes. The other purpose was, in the case of a war, having a source for borrowing, which was his justification for having a private bank, and getting foreign direct investment. So I think that Hamilton got into this aggregate argument because tying this to the enumerated powers only gets you so far, and especially tying it to the two fiscal powers, one being the power to lay and collect taxes, and the other being the borrowing powers. They don't get you a private bank that's being chartered by the United States to perform all of these functions. I get your point about what to call this, and I went back and forth on that. So to me, implied means not specified. Okay. Right. Implied means that we are recognizing a power in a government that is not listed there for one of two reasons. One is that it's a means for carrying out a power that is, but in this alternative mechanism, it's a means for carrying out an aggregate group of powers. So I do see these as implied powers. I'm not sure about the general foreign affairs power. One could talk about that as sort of an aggregate enumerated power, and I don't know the language. I think on the vesting clause and on some of the comments that Michael made about these foreign affairs questions, I guess part of my premise is, as I've written before, I don't accept the vesting clause theory. So if you accept it, you might come to a different result, but you still have to explain, even if you have the vesting clause theory, where does Congress get the power, right, to pass a code of immigration, right? Under the vesting clause theory, this would be something the president would be doing. And in fact, executives did it for a long time. I have more about it in a revision. It wasn't, it was in the immigration power, as Michael said, for a long time there wasn't I think you said this, but for a long time there wasn't any federal immigration laws. This started in 1856. There was a very, very limited passport power, and we can talk about that. It's really different than what we're talking about now. As one can see with immigration and entry in the United States, if we think about President Trump's policy of excluding people from certain countries, I don't see that being justified under the Foreign Commerce Clause. I don't see that being justified under the naturalization power. I see it as an instrument of, and the justification for it being foreign policy and national defense, right? But neither one is an enumerated power of Congress. So the vesting clause theory, it only takes you so far, but when you have to get into, even if you say the president has residual powers, which are in foreign policy, which I don't really accept in terms of policy making, you still have to explain these statutes that Congress is passing. And where does Congress get this power? The question on sovereignty, we have to talk about that outside. We could spend the rest of the hour talking about sovereignty. It's something that I really struggled with, but what I'm presenting here is what I think is the theory of sovereignty that American leaders came up with during the American Revolution to justify their theory of constitutionalism, and that after a ambiguous interlude with the Articles of Confederation came back into the Constitution. But even if you think that sovereignty is we the people, right, which I do, right, we the people of the United States, right, I do, and who was right in the beginning, I'm not sure, but I think sort of the Civil War settled that, and the way we look at it now, as we the people of the United States, yeah, I mean, that tells us something about the nature of the document. That's not a compact between the states. What it gets back to is whether that's some kind of independent source of power. And again, I mean, we get back to the preamble, but I don't think it is. I don't think it is, because what we have is the decision was made to split sovereignty and to separate the operations of government from the source of sovereignty, right? Before this, including Vattel, whom they loved, all the philosophers said, sovereignty is vested in the government. Okay? The big change that happened in the United States, and probably because this is the only theory that can explain federalism, is we got a system of divided sovereign powers. Even if you believe the Constitution is created by the people of the United States, the national government does not have complete sovereignty. It has sovereign powers. A point that Hamilton made very strongly in his opinion to Washington. The states also don't have complete sovereignty. Obviously not. They can't declare war. They can't enter into treaties. They can't do all the kinds of things that we consider attributes of sovereignty. So I think what we have to talk about is the allocation of sovereign powers. And the fact that it's we, the people of the United States, I don't see that that's a source of implying additional powers in the national government. But we talk about this a lot more, because reading a lot about sovereignty and trying to figure this out gave me a lot of headaches. So.
Can I just say very quickly about immigration that, in the debate over the Alien Acts, that even Jeffersonians agreed as to the Alien Enemies Act, and the principal source of authority was the war powers. And there was great disagreement over the Alien Friends Act, but the supporters of the Alien Friends Act invoked the naturalization power and the foreign trade power. Nobody, even though it would have been convenient at the time, nobody thought that it was an executive power.
Right. Actually, on the Alien Enemies Act, what the Jeffersonians said was it was authorized by the law of nations. That was, Gallatin was Jefferson's chief lieutenant, made a long speech. They actually introduced the Alien Enemies Act, and Gallatin relied on the law of nations, which was then considered part of the law of the land, even by the Jeffersonians. They didn't accept general common law. They did accept the law of nations as being a source of power. One of the things I say in the paper is that it may very well be possible that Wilson's thinking about the law of nations when he's talking about the second necessary and proper clause.
Our next group include Mr. Upham, Mr. McHale, and Mr. Green.
David?
A couple of objections, maybe more than, maybe as quibbles. When listing immigration power and naturalization and general foreign powers, given that you rely on Publius to identify some of these categories, it might be important to point out that the naturalization power he includes among the interstate commerce power. And this is a related objection. It may not be all that important, but the enumeration, the Article 1, Section 8 seems to have a certain order to it, which doesn't map nicely onto these things. I mean, many people pointed that out. It's just there isn't a foreign affairs section. There's a military section. There's a fiscal. There's a commerce section, and naturalization is bundled with bankruptcy. And I think the reason for that is because naturalization I've not published this, but the word naturalization in the founding era seems to mean admission to the rights of citizenship, a plural thing. And that plural thing includes the right to come into the country and the right to buy and sell. If that's the case, then the naturalization power, prior to what Congress finally resolves, the Naturalization Act 1790, is a complicated thing that doesn't mean here's a label and you'll find your rights elsewhere. But it means the right to, well, primarily where its placement is, the right to walk around and do business and own real estate in particular. So that may actually be maybe a basis for finding a fairly clear textual foundation. And lastly, back to that whole question of implied versus unspecified. There's implication from the grant of a power, but some of the things you call implied are implied or unspecified in a different way, and that is if what Michael said was correct, it's not implied from a grant of power, it's implied from the nature of the thing itself. If it's a human being, you can write a letter. I can write a passport. Tweet, I can do that. David Upham requests, as secretary of me, the permission to go. So it may be the word implied, but it might be important to imply and maybe indifference. Well, if our criticism is correct, that there's implication simply from being an association of free human beings or being a person, and then there's implied from a grant of a power that you don't have absent popular delegation of sovereign authority.
Mr. McHale?
Bob, I really liked this paper. I just admired so much your patience and even-handedness and the way you worked through the problems, and I agree with a lot of it. I wanted to make a couple points and sort of ask a couple questions. I'm intrigued by this clustering idea. I think there's a lot to that. As I mentioned to you in some comments that I sent you, there are other ways to think about clustering. So notably, Wilson in his law lectures, when he's describing the legislative powers of the government, he does something very similar, which is to say he runs through the powers of Article 1, Section 8 and groups them into different clusters. But what he then does is he links each of those clusters to particular enumerated purposes in the preamble. And you talk about the clusters as, aggregate powers that are clustered according to the essential purposes of the Union. But it certainly seems like one good candidate for what the purposes of the Union are the purposes laid out in the preamble. And along those lines, the one missing cluster here seems to me to be general welfare powers. I mean, that's the one that you are really trying to say doesn't belong. But I'd like to hear more about why it doesn't belong. I would think that under very prevalent 18th century conceptions of government, as you would find in Vattel and other writers, the essential objects or purposes of government are typically characterized as including many of the ones you mentioned, so common defense or national defense and fiscal and so forth. But general welfare of the population is a very conventional object or purpose of a government. And this kind of segues into Judd's point, which was very well put, better than I could put it, but it was something I wanted to put on the table as well, and links to something Michael said. So let's say that we take on board the idea that the United States is a corporation. And so some of these implied national powers you get because they're implied corporate powers. So Michael mentioned three of them: power to enter into contracts, power to sue and be sued, power to own property. So those are three of the five classic Blackstonian corporate powers that every corporation has tacitly and of course, and Wilson says the same thing. But one that Michael didn't mention, and I think is really the critical one here, is the power to adopt bylaws. The bylaw power is the potentially broadest of the corporate powers, and if I could sort of bring Jed's point in here, this is why, and Bill's paper, this is why the very fact that the Constitution emanates from we the people of the United States, a body corporate and politic that has been defined right at the outset as including the entire nation, is so critically important. Because if you grant the premise, and I think Michael did grant the premise, that the United States is a corporation and therefore has certain implied powers that all corporations have, it's not just the three that Michael mentioned, but it's also the power to pass bylaws for the better government of the body politic. that is essentially how the 17th and 18th century writers thought about corporations, including concrete illustrations like the City of London. The City of London is a corporation. It therefore has a bylaw power to essentially exercise the police power over the people of London. It's a body politic. Now, if that kind of an idea comes into your analysis, things really do start to change, it seems to me. It's a very different notion than the one you're trying to defend, but it would make sense in an alternative way of the language we're talking about, both in the sweeping clause and the preamble, and also the concrete illustrations of ways in which the government unquestionably right from the start has exercised unenumerated powers over the body politic of a variety of types, including legal tender and other internal examples, not just external. So I just wonder what you think of that as another way to think about this problem.
Mr. Green?
So, great paper, yada, yada. So what is foreign policy is one question I have. Seems like it's sort of talking and war powers of various kinds, so negotiating treaties, threatening to bomb, that kind of stuff. If you find those, it seems like that's your foreign policy power. So I'm curious. I'm like, a passport is active communication. He's one of our guys. And I apologize for asking the same question that I asked last year of Ilya Soman. Why isn't immigration power a limited declaration of hostility against particular people? So you've got the alien friends and the alien enemies. Is it telling well, you're my friend, but you can't stay here anymore? Why isn't that itself sort of taking somebody and say, well, you're kind of a JV level friend? So we have these three clauses that refer to invasions. Now, invasion is drawing a line, saying you don't go across that line, and it seems, I'm not sure, what is it? What would be in the immigration power other than something like that?
Not sure which questions to answer because they'll take time. Let me start with John. So I do rely on the corporate nature, as you know, for two of the powers, which I don't think can work otherwise, and that is the right to make contracts and the right to sue for enforcement of the contracts without enabling legislation. This is where I disagree with Mike. I don't see this as an implied power in the McCullough sense because in those cases, there was no statute authorizing the government to make contracts. There was no statute authorizing the government to sue. Of course, Congress had the power to pass those statutes in those areas. It didn't. And the Supreme Court decided on sovereignty grounds, which I think is wrong. I think the easier way to decide it is United States corporation. Under common law at that time, corporations had the inherent right to sue, to make contracts, so it would be sued. It didn't have to be in their bylaws. It didn't have to be in their charter. Okay. So where do we go from there? Okay. And I think here's my disagreement with you. And I can't help but talk about the preamble about this, right? So does the United States government, the national government, as a corporate entity, have the power to carry out the purposes of the corporation? Yes. Okay. The problem is, how do we identify those purposes? Okay. If it's a state government, it's really easy, because state governments have unlimited legislative power to do anything for the general welfare, unless there's a specific prohibition, right? The problem with the preamble, and then I'll follow it up with an answer to you, is this preamble could apply to any form of government. The same preamble could have been written for a consolidated United States. No more states, right? We're now France. We have a national government. And yeah, we'll have some kind of local autonomy with departments, right? But all power is going to emanate from the national government. exactly the same preamble. Okay? The Articles of Confederation could have had this identical preamble, and in fact, it used a lot of the same language. Not as a preamble, by the way, but as an article, right? Nobody thought that gave additional powers to the United States except James Wilson. Okay? So the preamble doesn't get me very far. We have to ask, how are these wonderful purposes to be effectuated? And the choice was federalism. Okay? So they didn't have to choose federalism. They could have decided the general welfare is better served by having extremely expansive power of all sorts in the federal government, including like running the schools. Right? Or they could have decided, as an initial matter, the general welfare is better served by having some issues be decided by the states and not by the federal government. And there are some essential matters, which are my 4 clusters, that are so important to the Union that they have to be powers vested in the government of the United States. So that's one of my answers to you. Do I agree that United States Corporation, it has, by implication, the power to meet its purposes? Yeah, but then you have to identify its purpose, the purposes of the Constitution. Okay? And the preamble doesn't help me very much. Okay? The question is, what did the framers decide on the form of government that best suited achieving these purposes? And whether they made the correct decision or not, it seems pretty clear to me that the decision they made was federalism. And my argument is that the way to achieve these goals that were set out in the preamble was by giving the national government these 4 clusters of power that were essential for each of those purposes. Now, I know that Wilson takes a different approach, sort of. But in a sense, it's the same. I mean, Wilson's trying to explain why these powers are important to making a more perfect union. Why are these powers and not others, right? Of course, in the ratification debates, nobody argues that the preamble is the source of power. Nobody, including James Wilson. Wilson, in fact, is the architect of the argument that the Federalists use that there is no general welfare power. Right? Now, maybe he was lying, maybe he was an advocate and he didn't really mean it, but this becomes the mantra of the Federalists. And I think there's a lot to be said for Max Edling's position that the Federalists were careful in what they said because they knew that if the Constitution gets ratified, what they said during the ratification debates is going to be a benchmark for what they can do in power. Okay. I got to talk about the preamble just because it's come so much, but so I've talked about it partially. My view is actually what Mike's was. There's 3 possibilities. Mine is the second. The way the preamble was being used by the Federalists was we have these ambiguous terms like necessary and proper. Right? How broad is the scope of this power? Jerry's entire argument was we have to construe necessary and proper broadly because of the preamble, because it's ambiguous. Therefore, we resort to the preamble as an interpretive device. Fisher Ames, and it has a speech for an entire day in Congress. He doesn't mention the preamble in that speech, although in a newspaper account in the Philadelphia Gazette, although not in the Annals of Congress, there's 2 sentences where they claim he does rely on the preamble. The reliances on the preamble, I think, are really spotty. They're not, they're not as, with all due respect to Bill, they're not as prevalent as one would think. There's one mention of it by one Federalist in the removal debate, and it's not a real theory for justifying removal. that's being used. There were 4 arguments on removal. This isn't one of them. So I think the preamble, I think they understood this. And what Jerry said was, he started his speech by saying, let's apply Blackstone to deciding how broad the necessary and proper clause is. Well, Blackstone had 2 principles. One is preambles didn't create rights. Second, if there's an ambiguity in an operative provision of the law, you use the preamble to resolve the ambiguity. So, the Second Amendment is an example like Heller. The majority doesn't think we have to use the preamble because they're convinced they know exactly that there's no ambiguity, right? If you think there is an ambiguity in what the term keep and bear arms means, then you would go to the preamble, and then Stevens would be right, okay? That's different than preambles creating power. Now, I know your argument is a little bit, different because you're talking about effectuating purposes, but again, my argument with you is there's goals and aspirations, which is what I see the preamble as being, and then there's how do we achieve these goals in structuring the government? What purposes of union do we need to give when we divide sovereignty? What purposes do we need to give to the federal government, to the national government, as opposed to leaving them to the states and to the people? So I really admire your work, and part of the article really builds on it. I think we just have this disagreement about how far this goes.
Just quickly, corporate law, corporations are limited by their charter. Within their charter, they have the power to have bylaws, but the bylaws are not can't go beyond the powers of the charter.
Yeah.
Our third group includes Mr. Sack, Mr. Solomon, and Mr. Smith, and we have about 7 minutes remaining in this session.
So thank you for the paper. I have to say, one man's modus ponens being another's reductio, it actually convinced me that the powers of the federal government are narrower than I would have thought otherwise. But I have sort of 2 families of questions. So one is, with regard to the law of nations and with regard to the common law, you seem the paper seems to argue that these are not sort of strong explanations. At one point, it describes the law of nations discussion as constitutionally irrelevant. And it strikes me that a lot of things are easier to understand if you think that there is some common law background that would affect the government's powers. So if the question is asked, like, why would they have left out a bunch of stuff? Well, one answer might be that they thought the law of nations was going to still go, and maybe it didn't confer powers, or maybe it sort of only guided their use, but maybe you just didn't need a bunch of things because you had the law of nations there. Likewise, maybe you didn't need discussion of contempt of Congress power or contracting or sue and be sued, because those are just common law things that would keep on going if they didn't say anything about them. And that allows for certain kinds of implied powers, but they're very different from the kinds of implied powers that you're deriving. The second thing, I just hope, if there is any time, I would really like a discussion of what exactly the bank could do that Congress could not do directly. Because, they can emit bills of credit, they can take deposits as a form of borrowing money, they can, build treasury offices in lots of different states. Now, they can't have it run by outside people. That would be appointments clause problems. But the ability to form a corporation is, perhaps a necessary and proper means to effectuating all the other things that the bank is actually doing. And then if that's true, then the fact that its governance structure is different from the governance structure of the United States as a whole might not be all that strange or controversial. So I'd love a discussion of sort of precisely which things the bank could do that the government could not do on its own.
Mr. Solomon?
Thank you. Really marvelous paper. I learned a lot from it. So my question is what is the constitutional theory underneath the paper? And in your answer to Randy's question, you sort of imply that it's public meaning originalism. So I'd just like to push back on the implicature interpretation of your paper. So unfortunately, the word implicature has two distinct meanings. One meaning applies to all forms of pragmatic enrichment, and another is sort of implicatures in the narrow sense. And in that sense, you don't have an implicature. This is not like the letter that you write for a student saying that you recommend them because they attended class regularly, and the implicature is negative. And this is not an impliciture either, or an ellipses it's sometimes called. You're not saying that there are omitted words. So the Constitution frequently omits "in the United States" because it's understood from context. This is not impliciture. Randy's example is the Ninth Amendment. That's presupposition, right? And the idea is that if there were no unenumerated rights, then it would not make sense to say that they cannot be denied and disparaged. I don't think you have a viable argument for presupposition here. There's a test for whether it is a presupposition or not, and presuppositions cannot be canceled, right? Unlike other forms of pragmatic enrichment. That is, if there's a true presupposition here, then a clause that said something like, and by the way, please don't infer from these enumerated powers that there are 4 other greater powers, right? That would involve a performative contradiction if there's a real presupposition, but it would not. The Constitution could have said that, and it still would have made sense. So I think that the actual argument you are making is a form of purposivism or objective purposivism or functionalism, right, as it's known in statutory interpretation. That is, you are arguing that the Constitution has a functional design, that when we understand the functional design, there are these 4 functions that the enumerated powers play. And then you're arguing that when we engage in constitutional construction, it is permissible to go directly from the functions to the legal content of constitutional doctrine. So that move is not allowed by public meaning originalism, but it is. You can think of this as sort of a form of originalism. Its original purpose is originalism, but original objective purposes originalism. I think you are not a classic living constitutionalist because you want everything to be tied to these original functions, hence your rejection of broader understandings of implied powers.
Mr. Smith?
Well, I wanted to just ask quickly, but in a serious way, the question that Steve Sachs kind of mentioned humorously, briefly. So if we reconceive of the enumerated powers in this aggregation cluster way that you do, which does seem to have a whole lot of attractive aspects to it, you offer that as a way of broadening national power to account for some powers that you say can't be accounted for very well in the sort of enumerated, more classic. But doesn't it have the potential to narrow national power as well? And if you look, think, maybe the main one, the commerce power. I mean, so can that be used as sort of a police power to deal with prostitution and lotteries and medical marijuana and so forth? Well, if you just think of it in terms of one power over commerce, it's not so hard to say, we know that it's been done, that those things all affect commerce, and they affect commerce that moves between states, and so it's okay. But if instead you think of this as a power to maintain economic union, it might be much harder to justify using that power in that way. So that might be one way in which this would actually narrow national power.
I did make the law of nations argument in the article that you described. I think it's a possible reason for these gaps, that they thought this was going to these areas, foreign policy especially, were going to be handled through the law of nations. And they did. They used the law of nations for it for quite a while. So our problem now is we no longer think the law of nations is part of the law of the United States or a source of power, right, for the government.
That's your problem.
That's my problem. Yeah. Well, it's my problem. It's, it's the Supreme Court. I mean, getting whether they're right or wrong about this, I think they're wrong. Okay. As an originalist, one would think that since both the Republicans and the Federalists agreed on the law of nations being part of the law of the land, and it was Thomas Jefferson who directed the Henfield prosecution. Okay. There was no disagreement between Hamilton and Jefferson on this. It may have been the only constitutional issue they agreed on, right? But that's not where we are now. So, yeah, I mean, that's our problem. And that's why I think also, the fact that I reject this idea of national sovereignty, which gave rise to a lot of these powers. We have to find alternatives. So, Larry, you're right. I don't think I'm taking a public meaning approach to this. I think it is an originalist approach, but I don't think it's a public meaning approach. One thing that it would have been really nice if I had found somebody actually saying this. That would have been great. Hamilton, I thought, came really close. I mean, Hamilton, but only in the terms of the purposes of the Union, right? In Federalist 23, which I thought was really important. So what I'm trying to do is explain gaps, and I would say that I'm looking at structure and history pretty strongly. And going back to a comment that David made, if you look at Article 1, Section 8, I mean, the first 7 powers are economic powers, right? And then the next are mostly military powers. Yeah, you've got stuck, the naturalization power stuck in there. But for those of you who hadn't read it, a lot of us have read Jefferson's opinion to Washington and Hamilton's opinion to Washington. And some of us have read them too many times, right? But there was also Randolph's, and we tend to ignore that. And you might want to take a look at that, which I used in an earlier article dealing with this great powers theory of implied powers. But one of the things Randolph said, which really struck home, was that don't put too much weight on the style or arrangement of the Constitution. He said it's not a literary masterpiece. It's not Hamlet, So he warned Washington against, placing too much emphasis on the style of the Constitution. And I've criticized Marshall for his reliance on the necessary and proper clause being in Article 1, Section 8, rather than negatively in Article 1, Section 9, because I don't think it matters, right? Because Article 1, Section 8 contains a lot of restraints on congressional power. Why aren't they in Article 1, Section 9, right? So I don't think we can answer this by just looking at style. I think we have to look at content and structure instead.